Hi, everyone. We're just letting folks in here. We'll start in just a second. Okay, we'll go ahead and get started. Hi, everybody. I'm Jen White, and I'm the Executive Director of Arise Immigration Services. We have a dual mission. We provide free legal representation to asylum seekers here in Pittsburgh and training and mentoring to advocates around the country as we work on our cases together. So tonight's training is a part of a 12-part series arising out of a pro bono project here in Pittsburgh. So basically, there's a new-ish collaborative. It's called the Collaborative for Immigrant Impact, and it's a bunch of organizations that serve immigrants in different capacities coming together to try to meet the massive needs. So this pro bono project is designed to equip lawyers who don't practice immigration law to take on immigration cases. So at Arise, we work with all kinds of folks with all kinds of professional backgrounds. So lawyers, non-lawyers, DOJ reps, really you name it. So these trainings are open to everyone, but they come out of that collaborative project. So tonight's training kind of piggybacks off of last week's training. If you were there, you listened to Danny White talk about ethics rules, basically. And so tonight's chat is more about applying the rules. Like, what do these scenarios actually look like in practice? So I'll go through a couple of big topics and we'll pause for comments, questions, thoughts. And also, Veronica Reinhagen will be chatting as well. She is a DOJ rep with Arise, extremely talented advocate, and will be sharing some of her experiences working on asylum cases. So let's see. Certificate of attendance. If you need that, email me. I will send it to you. And if you want the link to last week's recording with Danny, where we talked about the ethical rules, make a note in the chat and I'll send it to you. Okay, so overview of what we'll be chatting about. Privilege and confidentiality. And then we'll get into educating clients versus coaching, kind of that line between like what is zealous advocacy and then what is like lying, right? And then we'll be talking about related issues that come out of trauma, because we all know that brains that have dealt with trauma are not always super accurate, and we have to navigate those situations in the world of humanitarian immigration. And then we're talking about helping our client tell their story in light of very difficult legal requirements that we have to prove. And then we'll end with conflicts of interest. So we'll jump right in. As you know from last week, ethical rules do tend to be very gray. Like, some are super concrete, but having watched a lot of Danny's trials, I can tell you that there is a lot of room for disagreement among reasonable minds about these rules. So that's why we want to talk about it, right? We want to learn and be as ethical as we can be, because the ethical rules are designed to protect vulnerable people, right? That's the whole point of this. So privilege and confidentiality. I like to think about, like, right, like ethics for dummies, right? It helps to actually understand the basic principle before you can apply it. So confidentiality is very broad. It generally means that you do not disclose anything about your client or their case to anyone. Very broad. But of course, there's exceptions to that. When your client authorizes you to make the disclosure, there's a bunch of exceptions listed in the rule here in Pennsylvania. Like, for example, you can disclose confidential information to prevent reasonably certain death or substantial bodily harm. But the general rule is you don't say anything that would disclose the information. But privilege is, I think, a little bit more complex. So privilege is generally about whether information can be revealed in response to discovery or a subpoena or during testimony. So it's generally about like an adjudication process. So it's a little more narrow in scope, but it's a similar idea, right? It's about keeping the information private to protect your client. So I'll give you a couple examples of this because it's really easy to forget even things as basic as confidentiality. So I remember maybe about 8 years ago, I was working at a legal aid organization in the DC area, and we helped survivors of crime, persecution, all kinds of things. And my supervisor reminded all of us staff attorneys, she said, remember, confidentiality means if someone calls you, you cannot confirm or deny if you represent the client. And she was saying that abusers had called to see whether or not we were representing their victims, right? Because they wanted access. And so that might seem obvious. Hopefully that is obvious to you. But if it's not, that might be because, like, when you're working up a case, you interface with so many people to get information, and your client authorizes you to do that. That's why you do it. So it can be easy to forget the real scope of confidentiality. Similarly, I just dealt with this today. A social worker called me because she was providing some services to a client of mine. And it sounds like the relationship kind of deteriorated. And so she wanted to know whether I told my client XYZ. And so I told her I can't disclose that. And she tried to push me, and I said, I'm not going to do it. So, you don't necessarily make friends when you are trying to be ethical. I think a lot of people don't understand how rigid our requirements are, but it's important, and they're designed for protection. So yeah, so some people won't understand, and that's not our problem. So thinking about privilege and specific to the work that we do. So we focus on asylum cases, right? I want to give you an example of when privilege would protect your client, but you might not want to invoke it as an argument, right? Because we have to weigh ethical issues against like real risk to our client. So this is something that has been happening about the last 5 or 6 years. Clients go to interview for asylum, and the asylum officers can be pretty invasive with their questions about how the case was assembled. So they ask questions like, did anyone help you write your affidavit? What did they tell you as you were writing your affidavit? What kind of advice did they give you, if any? Almost all of that, if not all of it, is privileged, right? Meaning it should not be admissible during this testimony because it's protected by attorney-client privilege. But consider the ramifications here. Asylum is discretionary. Credibility is a huge deal at asylum office interviews. So do you object and say, officer, like that's inadmissible, attorney-client privilege, blah, blah, blah? Or do you let it proceed, right? And take your chances? This is the way I have dealt with it. As soon as I learned that this was happening, I started preparing clients for it. And this is difficult because if you try to explain privilege to most clients, it's really difficult. However, the way I explain it to clients is like, look, we have nothing to hide. You have to disclose so much during the asylum office interview anyway. You can explain that I helped you, that you were telling your story and I typed it out. That's fine. Like, I hope that you feel comfortable to describe what happened because you don't want to look cagey, right? That is not what you're going for in an asylum office interview. So that's the way I've handled that. What's interesting about immigration processes is that they're really invasive vetting procedures in place for people to get immigration benefits, right? So this is not like other practice areas where you might be able to invoke privilege and other like protective doctrines to protect your client. The reality is the background checks are extensive. Your client has to reveal a lot of information about themselves in order to get a benefit. So that changes the dynamics a little bit because you want them to present as trustworthy, right? So, in light of that, I think it's smart to think about strategy, right? If your client does have something that is not flattering for them to disclose, a lot of times the smart move is to get out in front of it and disclose it. Like, for example, maybe it's a criminal conviction that it does not bar them from asylum protection. You get a certified copy of the final disposition. You include it in the affidavit, explain rehabilitation. Hopefully that's happened, right? Own it, right? Ask the client if they've taken responsibility. If they have, include that. So the idea is you don't want to hide things from the government because that generally comes back to bite the client. But this is very different than a lot of other practice areas. So you really have to weigh the protective ethical rules against what can actually happen to your client and potentially backfire if you're overly protective. Okay, so that was a lot. I'll pause for thoughts, comments, questions. Okay, so moving on to educating clients versus coaching. I think this is in some ways a little more gray. But one of I think the most important ethical rules for lawyers is that we are required to be zealous advocates. Like we're not supposed to be passive, we're not supposed to be selfish, right? We are zealously advocating for our clients' interests to protect their legal rights. Um, if you've interacted with a lot of lawyers, you've probably seen them not do that, unfortunately. But that's what we're supposed to do. Um, and so part of that entails like helping your client present their story in a way that's compelling and satisfies the elements without misrepresenting, of course. So I'll give you an example from a case about 9 years ago. Um, so you're probably aware for asylum, you have to prove objective fear, meaning the fear is reasonable, the fear of persecution. You also have to prove subjective fear, meaning you're actually afraid, like really afraid. So that subjective fear can be interesting because our clients tend to develop really impressive coping mechanisms, and they don't seem that afraid sometimes when they come to us because they've been living in harm's way for a long time, right? Versus like if you would substitute someone who's been in America all their lives and subject them to that kind of threat, they might be terrified. So years ago, I was working with a gentleman from Iraq, and he was Kurdish, highly educated, and provided really interesting explanations of his fear and the vulnerabilities arising from him being Kurdish, and even like some of the persecution his father faced. But he was highly academic. Like that's the way he learned to compartmentalize his trauma, was he put it like in a textbook form, right? And so I thought it was very interesting listening to him. But when we got to preparing for his interview, um, he was very like mechanical, uh, completely flat affect, and did not seem afraid at all, even though he could tell me in our other conversations that he was afraid of being killed. So I remember asking him during this moot session where I played the role of the asylum officer and he was preparing for his interview, practicing like he was there. I asked him something like, what are you afraid of if you return? And he gave like a just a very bad answer, like, well, I'll figure out a way to survive. That's not a good answer. Not a good answer at all. So when we finished the moot, my feedback to him was, you don't seem fearful at all. This is a requirement for asylum. What I did not say to him is like, you need to look afraid, look afraid. I think that's unethical. You're kind of encouraging a misrepresentation or like your client acting or feigning something. But I did tell him, like, if you're afraid of being killed or being attacked, like physically beaten, you should give voice to that. Like, are you afraid? So you ask these direct, pointed questions to try to get the truth out, right? So I knew enough about his story at that point to understand he was sincerely afraid. But you want to help your client articulate those things. And I think that's being zealous. I don't think that that's helping them misrepresent the truth. I'll pause there. I wonder if anyone else has had similar experiences. Okay, so moving on to when a client does want to misrepresent something. So a lot of folks who have fled persecution and who have lived in hiding for a good chunk of their life, they have learned to say what pleases people to get to safety, right? Or they've learned to lie to escape unsafe situations. And so these are things we have to navigate, right? So just because someone was dishonest in the past doesn't necessarily mean they're going to be dishonest in their immigration case. It can be a survival mechanism. So a couple years ago, we had a woman from Afghanistan who was in a polygamous marriage. And like so many of these issues, it was kind of complicated and it took a while for it to come out. And the issue for that is like, so for polygamy, this is actually really fascinating to me. The rule is that, like, I'm going to use myself as an example. Like, my husband's Danny, right? Say I have a second husband that I just married, like very recently. Danny was my first, this is my second, like, polygamous husband. Then I come to the United States with my second husband that I married more recently. I cannot include that husband, the second one, the recent one, on my application for asylum as a derivative. I can only include Danny. The government will acknowledge that first marriage because it's not polygamous. The second one would be. So anyway, we explained this to the client that she couldn't include her, polygamous husband in the application, blah, blah, blah. She was not happy to receive that information. And she said, well, can't we just tell the government that, I was never involved in any polygamy. I just have this one husband. And so we explained to her, no, like we cannot help you misrepresent the truth. We understood where she was coming from. We didn't feel the need to withdraw the representation. We just explained to her, like, no, we can't do that. We do not recommend that you do that. And so if you want us to continue representing you, we need to tell the truth and we'll help you tell it. And so that's what we did. And ultimately, her case was approved. But I think it can be easy to be creeped out and jump the gun as well and want to withdraw quickly. And that might be fair. It might be fair if you think that you would be helping a client potentially misrepresent the truth and they might lie in the interview, right? Then I think that is fair to withdraw. Because if you are at the interview and they do lie, then you have an ethical responsibility to correct that lie. So this is why this gets gray, right? You have to do some predicting about what the client may or may not do. Thankfully, this particular case just worked out. Okay, so thinking about trauma as it relates to misrep.
I'm sorry, I have a question about
Yeah,
that.
go ahead.
Hold on. This disconnected. Can you hear me? Okay.
Mm-hmm.
So I'm sorry, I'm trying to have dinner and listen to the class. Um, I was on an interview and a person came on a visa, and I guess when she was interviewed for her visa, she was um she said that she was coming with her husband to visit. And that was, I guess, the person who did the interview put that she was coming with her husband, but she never was married. And the officer kept bugging into like common law and this and that. You have to prove that you never was married. And but is there a certificate that shows that you were never was married?
A certificate that shows you were not married?
Hold on a second. I think this is okay. Sorry. Go ahead.
A certificate that proves you were not married? Is that what you're saying?
I can't hear you. I think this went bad. Sorry.
No worries.
Uh,
We can circle back.
I'm sorry. I can hear you, but it's partly my fault. We can come back to that question if you can.
Sure.
Oh,
Yeah, just
I'm sorry.
okay, go ahead. So the certificate proving they weren't married? Is that what
Yeah, he can say that you have to do. Well, okay. The lawyer who was there was like, "Oh, you need to find out a certificate showing that you were never be was married." She just left with this guy, and then I'm like, does she was from Colombia? Like, does this exist?
I've never heard of that. A certificate proving you did not marry. I've never heard of that.
Exactly. So I'm like, she asked me after, and I'm like, I never heard about that. Can you do like an affidavit and get it notarized, like stating like I was never married to this guy. I don't know what the ambassador they put that. I was married.
Yeah, I don't know why that would help.
Okay.
Yeah, but I don't I
But
don't handle many family-based cases.
okay.
But yeah, like in general in immigration, you can have a sworn affidavit notarized as evidence. You can do that in general.
Okay. Thank you.
Sure. Okay, so Vero's going to talk about dealing with discrepancies and trauma and things that can kind of complicate this idea of trying to help your client get their story out and remain truthful.
Okay, so I have an example of two cases where there was a lack of consistency. The first one, a little bit like Jen's, in that the lack of consistency was between the story and the client's demeanor. And so whenever she told her story, her demeanor was, she almost had like a smirk in her face. And that this became problematic when we did the moot, um, because it almost looked like she wasn't telling the truth. Her demeanor, her affect did not line up with the story. And we cannot coach them into feeling a certain way or pretending to be upset. Um, but we can use the opportunity to sort out the discrepancy and educate them about it. So I took the opportunity to say, listen, and more specifically, when I would ask a question, for example, are you afraid that you could be hurt, or what could happen to you? She would pull something like a duh, like, of course, in that kind of attitude. And I'm like, this is not going to be good if she does this during an interview. But again, I cannot coach her. So I took the opportunity to say, listen, I know that these questions are obvious and maybe silly to you who you've lived through this. But the reality is that the people that are interviewing you don't necessarily know the details about your country, about your case, and perhaps they've never heard about one from this country. So try to keep this in mind when an obvious question is asked. And rather than sounding dismissive, just sit with that idea. So we typically do a couple of moots before the question at the case interview, and it got better. It didn't completely go away because that was a little bit of a coping mechanism that she had, and her personality, but it did get better, and she did not look like she was saying, uh, your question is dumb through her face. So that worked out well. The other one is we were getting ready to file a case, and and in one of the I believe it was the last interview that I had with the client, um, she expressed that her daughter was almost raped. And this was something that had never come up before. And I said, uh-oh, well, if this is true, then we have to reconsider what we had. We had the whole case pretty much wrapped up. So when these things come up, you want to identify them right away. You want to discuss them openly with the client. You want to seek clarification. You want to write it down and write notes, perhaps, that you address this. So it turned out that she had been concerned that her daughter could, or one of her daughters could be raped because she didn't trust the environment. But there had not been any actual um, situation where the daughter had been approached or attacked or anybody specifically. So we sorted that out. Um, and I made a note of it just for my own record. So some of the other part of that same case was an affidavit from a relative that we received, and the affidavit from the relative indicated that our client had been uh, attacked and almost killed during a robbery. And that didn't square up with what, through many interviews, we had uh, on the affidavit. And so I went back to the client and I said, okay, the affidavit from your family member confirms this incident, and I want to get a little bit more information from you. And so it turned out that yes, she was robbed, but she was not uh physically attacked. And so they did not try to kill her. They really wanted to take her cell phone and her money. And so we sorted that thing out as well. So, these are two important pieces of information that could lead to, oh, okay, tell me more. You were almost raped. And, pull the reality wasn't that it was not the case. So sometimes the information comes from trauma and from that heightened fear that something more can happen. Sometimes it happens from, I think we touched on this in the past, in language used in translations when you're dealing with a client that requires an interpreter. And sometimes it has to do with the passage of time and people's perception of how events unfolded. So our job is to investigate the discrepancy and present it in the most accurate account possible. And a discrepancy is not necessarily a credibility problem. It's often an invitation to ask for more information, to ask better questions, and understand the client's um, experience more fully and ensure that the record accurately reflects what happened. So those are my two most recent situations that we've experienced.
Super helpful. Yeah, it was occurring to me as you were explaining that first story about the woman who was smirking and just like having a pretty obviously bad reaction, right? You do not
Yeah.
want to be like sassy with the asylum officer. Um, it's interesting how much you have to over communicate with these cases, or at least to me, it feels like over communicating. Like, obviously, we're trying to help, right? Obviously, they need to come off as like sincere, honest people. Like, you'd think everyone would know that. But those extra explanations, like, look, we're trying to help you. We want you to have your case approved. And kind of like Vera was saying, like, these are stupid questions. We know that. This is an exhausting process. I'm sorry you have to go through it. Like, those kind of explanations really do go a long way. Because I do think the process itself can really piss off a lot of people. Understandably, it is exhausting. So I think sometimes we see those reactions in our clients, like, how many times do I need to explain this to you?
Yeah.
Yeah.
And to your point, Jen, she would say things like, this is on the paper. This is on my declaration. You've
Yeah.
already asked this.
Hmm.
And I was personally offended by the way she was handling it.
Yeah.
So I said, this is not good. If it's up against an asylum officer, he won't have patience for this. And so we sorted it out.
Yeah, when you did a great job. Like, this was a case that was approved during Trump 2.0, and it was an Afghan case. So, yeah, it was amazing work and a very difficult client, I have to say. Okay, so in terms of framing the story, I have a couple things outlined, but I would love to leave it open and see what would be most helpful for you all to talk about when thinking about, like, specifically the affidavit. A lot of people have uncertainty about how you can help a client do that. So does anyone have specific questions about that and kind of, what does this look like in terms of where's the line for coaching versus appropriate advocacy? Go ahead, Jennifer.
Okay, I think we've talked about this before, but some clients aren't going to have as good of written skills and then also some clients talk in a circular way versus a chronological way. So where is the line in how you can help them put that in a logical explanation in their affidavit?
Yeah, so the clearest, simplest way I can explain it to you is if your client isn't real sophisticated, does talk in circles, can't tell a sequential narrative, I ask questions as they talk, and then I only record the things that matter, and I leave out all the other stuff. And then I try to make it sequential as much as I can. And then, of course, you either read it back to them if they're unable to read themselves, or you have them read it to verify. But that's perfectly appropriate if you're only capturing the necessary portions and it's coming out of them, right? And leaving out all the confusing stuff. That is such a service for your client, because trauma can prevent that, like in their brain, from being able to do that. And there's also serious cultural barriers too. All of us know this, but like in the West, we're much more sequential than other parts of the world. So yeah, that's the easiest way I can explain it. There's all kinds of tactics within that. But I would say if you can see that that's going to happen, just try to take the reins a little bit and say, like, look, I'd love to help you write your affidavit. Like, don't even leave it up to them because they might struggle with it, so long as they're comfortable with you helping them. And then the last thing I'll say is, generally in terms of rapport building, I try to interrupt less at first because I don't want to be rude and that they're telling me very sensitive things. But then, like, maybe we've met 2 or 3 times. By that third time, I'm interrupting a lot, because I need to get what I need to get as respectfully as I can. And I tell them, like, look, I don't need to know about this. I do want to know about this. I am trying to help you, because you've got to get what you have to get. And that tends to work well. Go ahead, Tatiana.
Hi. You remember I asked a question last time we talked about this because it was like important for me, but I made for myself in my brain at least, I made a plan. So to ask a client as many questions related, and more you meet with them, then more you know what clarifications to ask them about. And then you just put on the paper everything that they say. But you also need to you cannot use the client's language. I mean, not like a language in terms of the country. I mean, how they speak. We still write in our own style and own language, right? So is that okay if we convey everything that client says? But we
So it
know
doesn't,
the facts, but the only thing is like when client starts to talk, the officer or judge, everyone understands that it's not the client who wrote that. Even if I read it back to him and he signs it, is that okay?
so it should be in the client's voice. Like, so for example, most of our clients speak imperfect English if they speak English at all, right? Because it's their second or third or fourth language. It should sound like how they talk. It does not need to be a transcription. It can be a summary in their voice, and then they go back and they affirm it, right? But and it's fine to disclose, like we talked about earlier, that you helped them, like they talked and we typed it out, but then they confirmed it. But it should definitely sound like them in terms of how they think and in terms of how they actually say words and frame sentences. It should sound like them because it can cause a credibility concern if it doesn't, if it sounds like you and not them.
Also,
So
I'm sorry.
I'm sorry. So I cannot put there that it's written exactly from the client's words, but I was the one.
So a lot of times what we will do is at the end of the affidavit, like say it's a client who cannot read or write,
Exactly.
very limited education.
Mhm.
that could raise questions, right? How do they put this in writing? So we will often put at the end of the affidavit, my lawyer helped me write this. I talked to her while she typed it out, and then I read it and I verified that everything is true. And I think that's a great way to cover your bases.
Yeah, and another question, when you talk to them and when you ask the questions, can you just record the client just to make sure that you convey everything right when you review it, when you rewrite it, when you restructure that you didn't forget anything, that you used client's language and style as close as possible?
Yeah, as long as it's they give consent and it's kept confidential. Yeah, absolutely. Go ahead, Vera. I think you were going to say something.
No, in terms of the language reflecting the way that the client speaks. It also has to do with when you read it back to the client or when they read it or read the translation or whatever it is, that if this is not a sophisticated person, um, and you write it in a register that is more formal or legalese or whatever you want to call it, the client's not going to quite understand perhaps what it all means. So you have to keep that in mind that when you write it, it should be the client's voice because also the client has to be able to understand it.
I think I saw another hand. Did someone else have a comment? Okay. And then in terms of the 589, so that's the application for asylum, or really any of the immigration forms where you have to provide substantive answers to questions. Those forms are designed to screen for whether the client satisfies the legal elements that are required to approve the benefit request, right? So the way we do the 589 generally, there's a whole bunch of substantive questions on there. We do that toward the end of the case preparation, incorporating in the client's affidavit, that information. And then, of course, we read it to the client or have them read it to verify it. But again, I think it's really important that the advocate does this. There are attorneys and DOJ reps that have the client do all of it. It's just they're not positioned to understand the legal requirements. So the client is the master of the facts. We are the master of the law, but we have to connect the two, right? And so I just think it's bad practice to put all this on the client. I think it's much better to get everything you need and then put it in writing and have the client verify it. So that's what we do. Any comments about that or questions? Okay, then we'll move on to interview prep. So, Vero, go for it.
Okay, so one of the things that we do is provide our clients with about 3 moot sessions for their asylum interview, one right away, and then we kind of wait till we know that the interview gets closer. But in terms of discussing coaching versus education, I have been in moots where the practitioner has said to the client, I recommend that you study your affidavit, okay? Which can be a disaster, right? So the mock interview is primarily an education tool. And we do not script or coach answers. We don't say, study this answer. We never want to do that. The purpose is to reduce the confusion and help the client understand to relieve anxiety that can hinder the success of the interview, and also for your own as the client, as the rep. So what we want to address during that process is who's going to be present at the interview. Um, I like to even tell them what the room looks like. how big it is. A lot of times they think that it looks like a courtroom and there's a judge up there. And I want to make them familiar with the environment. We want to tell them how the interview is going to be conducted, how long it may or may not last, although we do not always know, the types of questions that are going to be asked. They're going to be asked the biographical information on their I-589, and also the importance of listening to the question and only answering the questions that they're being asked. And if the asylum officer wants more information, they're going to ask those follow-up questions. Um, Also, in many cases, we have an interpreter, so getting them used to speaking with a pace that makes it easier for the interpreter to work with them. So those are the kind of questions that the type of issues that we address when we have a moot interview. We don't use that to tell the clients what to say. They know their story. The goal is familiarity with the process and not necessarily rehearsing a script and answers, because when nerves set in, it could be a formula for disaster. So a prepared client is usually calmer, more focused, and better able to communicate their experiences. And so are you. So that is the purpose. It's not the purpose of those moots are not to uh, coach, but to educate and to give them feedback at the end. Um, what else do I have here? I'm sorry, I'm losing my voice, I think. Um, so about, I'll set this up. I'll set this up. Okay, I'll touch up on the interview outline, and then I'll hand it over to you, Jen, for the the ethical issues with different roles.
Sure.
So one of the things that we give our clients, rather than telling them study the affidavit, which is a terrible idea, is we give them a brief outline for their interview, which is very different from scripting, right? And so the useful distinction here is the difference between an outline and a script. An interview outline identifies the major topics, right? It keeps, and we usually have what, like 4 or 5 points, very short chunks, because they can't go in there with papers and reading off papers. And memory, when people are nervous, can be tricky. So that little, we used to call it the cheat sheet, but we're going to call it the interview outline, right? Um, uh, Touches on the major points of their case, like the harm that they suffered, right? If there were two main incidents, okay, this incident and the other incident, what happened to them, what they're afraid of, and more importantly, why are they requesting asylum, right? And with the moot, you have the opportunity to ask this question a couple of times because, like in Jen's case, they might say, you know, well, uh, I'm a, I'm afraid, I'm not sure, or I have a better life here, or something like that. And we want to drive the point of why it is that they're filing for asylum. That little cheat sheet might say whom they fear and why, so that they speak to the nexus on their case. And these are things, of course, that the asylum officer will suss out with their questioning, but you want to keep them focused on those important things because they might get lost in other details and forget. So the outline helps clients understand the structure of the interview and highlight the most salient points of their case. Um, a script, however, provides specific answers for the clients to memorize, and that is where the ethical concerns arise. So do not script the interview. When clients try to memorize a testimony, even if it's true, it can sound unnatural. Um, the important details may be omitted because they're trying to remember too many things. The follow-up questions, they might not be prepared for those. It may just throw them off their game. And the credibility concerns may arise if the client departs from the memorized version. So don't do that. Um, And what else do I have here? Let me see. So the interview preparation is about education, not coaching answers or embellishing facts or over dramatizing emotions or trying to convey how they should act. Um, and so we help them succeed at the interview by organizing those facts and identifying legally relevant interview issues while reducing anxiety, which is super important. So, and that's how we preserve the integrity of the process and their testimony, and we balance those things.
Super helpful, Vera. Yeah, so an interesting thing to think about. Since I've been doing this for over 10 years, I've really changed the way I practice because of the backlog and the busyness and the chaos that exists in the immigration system. So I used to help clients write very long affidavits. Now, max, they're 3 to 5 pages. We really try not to exceed that. And so part of that process means leaving out some dates or other specific details that they might not be consistent about. Just leave them out if you think they're going to contradict themselves. However, if they are consistent, say about a specific date when the past persecution occurred, right? Well, if I include that in the affidavit, then when we go to make that outline to give to them, the interview outline, I will include that date in the little bulleted list, right? On this date, such and such happened. I pulled it from the affidavit because I'm hoping that they don't contradict that date, right? So this is where this is different than a script, but we're just giving them what they already gave us, right? Hoping that they don't contradict themselves, setting them up to be credible and to remember what they already told us. Okay, so Vera had mentioned roles. So one person can play multiple roles during the course of any immigration case. So for example, Vero is an interpreter on many cases, and she's also a DOJ rep, meaning she represents clients with their cases. One thing you want to avoid is playing dual roles when that could be unethical or create the appearance of bias. So like we've dealt with this with Vero, where she was helping a client assemble their case and also interpreting. But I was also helping this particular client, and I ended up submitting the application and listing myself as the legal advocate because Vero was the interpreter listed on the application. And it would be important, especially in this really harsh environment, to make sure that we don't create that appearance of bias because that could be pinned on the client. I've actually never heard of that happening, but it's a legitimate concern. So we're careful with that. I'll pause. Comments?
And there was a interpreter, and I had also done the translations to all the documents. So the certificate of translation were all mine.
Okay, we can go through conflicts of interest. So we talked about this last week, kind of the dummy version of conflicts. It's when your client's interests are no longer aligned. That's the way I think of conflicts of interest. So one of the common examples you're going to see in this line of work is divorce, because a lot of families apply for immigration benefits together. So we had this happen about a year ago. It was an asylum case, and we filed it. So the wife was the principal, husband was the derivative. What was interesting about this case, though, was it was a very amicable divorce and like a situation. So they reached out to me and let me know, like, hey, we're getting a divorce. We would like you to continue representing us, but we're probably going to have to sever our cases. Like, what does this look like? So because this was an amicable situation and the proceeding had not commenced, like no one had filed yet, they just knew they were going to do it. The way I handled it was, and this is in light of understanding that there's a shortage of high quality immigration advocates, understanding that, like we deal with those practical realities. I reached out to both of them on this email thread and I said, like, oh, I will be conflicted out. If you want, I can meet with you both together and explain to you both at the same time what this looks like legally for both of you, right? And I can refer you both at the same time. And so they both were comfortable with that. That's what we did. And I said, look, like at the point where one of you files against the other, that's where I'm immediately conflicted out. So I will have to withdraw from both of you. But it was really nice because, as I mentioned, there's a shortage of advocates. We were at least able to get them on a path for both of them. And that's what they wanted anyway. If it was more contentious, that would potentially be a different situation. But there is a bright line for some of those cases, like when litigation commences or when like one files um, like a legal action against the other, then you withdraw. So because because a lot of families apply for relief together, it helps to anticipate these conflicts when you can. And again, the reason is because there's a shortage of advocates. So I have seen many times, it's really sad. I have a couple good friends who are immigration lawyers. They've been in a position where they do U visas, so for victims of crime. And kids involved in those cases end up being abused while their U visa is pending. And there's a protective order action, like one against the other family member, when they were all clients of my attorney friend, right? So at that point, you withdraw because there's a court action where it's one party against the other, they're both your clients, you withdraw. And so then a lot of times these folks, all of them are unrepresented. They can't find anyone else to take on the case because there's just not enough people doing this work. So that's why I really try to be intentional about anticipating what could be a conflict. It's not that like we think we're the only people who could do this work. It's just that there's not enough out there and not enough people doing it. So they might be in a position where if you take on the case for everyone, then everyone is just in a pickle when you have to withdraw. So we had this situation recently. We got a case about a year ago for a case involving suspected trafficking. We didn't really know, but the juvenile client was my client for asylum, and his caretaker was a refugee that was ready to adjust status. So I was thinking about like helping them both. I could have taken the adjustment case, but then I thought, no, like if this trafficking turns out to be true, then, there's going to be a conflict there. I'll have to pull back out of both. And I really want to help this young, vulnerable kid, right? And not be in that position. So that's why I didn't offer to take on the adjustment case. Because I know for a fact now that he would never have found representation because the case was too complicated. So it helps to just keep that in mind so that you can keep representing clients for the long term. Okay, that's all I got. Vera, do you have anything else?
I don't.
Comments, questions? Go ahead,
So
Jennifer.
can you do an initial consult with like two people and then say you can only take one of them? Or should you not even do an initial consult if you think there might be a conflict?
Oh, that's a good question. It's kind of is fact specific. Do you have something in mind?
No, I'm just thinking like the case that you said, the with the refugee and then the trafficked or possibly trafficked
Yeah.
person.
So, yeah, I think at this point I'm aware enough not to do that. What happens though is, so this is common for us. We have one principal applicant, and then the rest of the family applies as derivative applicants based on that principal application. I think it's okay to move forward as long as there's no red flags. To move forward, having everyone together so long as they consent to that. Because sometimes that helps. You just get information easier, whatever. People sometimes are more comfortable having loved ones with them in an interview. So I think it's okay to proceed until you know there's an issue. So yes, like having joint intakes or interviews, I think that's fine. Does that answer your question?
Yes, it does. And then also, I'm just wondering, how do you know when you just shouldn't take a case because there's not going to be, they're not going to meet the requirements? We have, I live in Arizona, so we have a lot of people from Mexico, and I know Mexico's super hard place to request asylum from. Um, but I had a student from my English class, and an attorney took her case, and now it just got pre-terminated. Is that the right term?
Yep, it is.
Um, and they took thousands upon thousands of her dollars and her son, who's a derivative of hers, and I don't think they did anything.
This is a huge problem. It's a great question, Jennifer. And frankly, this makes me livid. This is happening all the time now. Attorneys and others are profiting off of this mess that we're in and the legal vulnerability that immigrants, um, that every immigrant is dealing with right now, really. So there's a lot I could say about that, about like possible excessive fees, like as a rule violation, and maybe you want to consider reporting them. I'm not sure of the details, but um, it really depends on the procedural posture of the case. Like if it's a legitimate claim, arguable, and you're in a defensive context, that's one thing because the government's already prosecuting you, trying to get you out of the country. Maybe it's just like your last chance to apply for relief. If it is cognizable, and the client wants to do it and they want to spend the money, they're informed, and that's the key, right? Informed, um, then that's fine, right? But for an affirmative context, it's a little different, right? Because they're not necessarily on the government's radar yet. And there's a lot of money ahead with affirmative because generally people have to pay for that representation for the affirmative case. And then if they're switched to removal proceedings because they're denied at the first bite of the apple, it's a ton of money there on out and a lot of time, right? So, and the alternative is just not doing anything and like perhaps waiting for a better administration. I think the key is there's two things. One, that the client is informed and understands, right? We, of course, can't speak in percentages, and it's really hard right now because this administration completely lacks transparency. So they're not giving us the usual data and statistics. So we can tell clients more. They just aren't doing that. But we know that denial rates are very, very high, especially in immigration court. So it's really important and the ethical thing to do to educate, right? And explain, even if you think like the chances are really slim, that attorneys need to do that. Um, and if the client wants to go for it, that's great. I had a second point and it completely escaped me. Sorry, Jennifer, this stuff really bothers me and it's wrong. But if you know like the fees that were charged and you want to talk further, let me know because
Okay. Yeah, I do. I do.
yeah.
And I mean, I'll tell you, I cried coming home. I cried
Oh,
coming home from her house.
I'm
She's,
so
she's
sorry.
pregnant. She's
Oh,
due next month. It's just,
I'm
it's
so
a terrible
sorry.
thing.
It is. It's really wrong.
Yeah.
Yeah, well, I'm happy to chat further
Okay.
if you want to take some like action. Yeah, I'm so sorry.
Yeah, I can just tell you the organization that I volunteer with, and I can tell you what they did. On another time I can touch base with you
Sure, of course.
because it's hard for me to know uh if this is what all attorneys charge. It seems excessive to me.
Yes, and it's a huge problem right now. And we're seeing it, it's all over the place. And part of the issue is that fighting these pretermission motions from the government, it is a lot of work. So you can understand why high fees would be charged.
Well,
The
that wasn't even for
issue,
that part. They didn't even represent her for that. That was
oh,
only for the
okay.
initial part. And then now they're like, oh, well, it got pre-terminated. Here, we need more money if you want us to fight it.
Okay.
So, yeah. Anyways, I'll talk to you about it later. I don't want to take up the time now.
Yeah, no, I'm
Yeah.
so sorry. It's awful.
Yeah.
Go ahead, Tatiana.
The question about representing like a family, um, can you just in their retainer agreement put that in case of the conflict, so the parties are aware that there might be conflict of interest. You say that in case of the conflict, the attorney represents like keep representing a woman unless the party agree to otherwise. Just to put there, so you don't need to stop representation of both of them. You
So
have
some conflicts are waivable, some are not. So you'd have to look at the rules based on where you're barred. And so there's different rules with current clients, past clients. Some are not waivable, but the ones that are, you should definitely get it in writing, like I think you're saying, and get their signature and, of course, educate them about what they're agreeing to.
yeah, but you don't know. You might not know at the beginning whether there would be that conflict that your knowledge about the other of your client would prejudice one to another.
Yeah, so these things evolve, right? But there are certain conflicts that aren't waivable. Like, for example, if one client is a party against another in proceedings, right? In some sort of litigation, like then that's not waivable. You have to withdraw. You can't represent both.
Even if the information that you possess does not prejudice anyone.
Yeah, it's not a waivable conflict. You have to withdraw.
Okay.
Anything else? All right. Well, thanks everyone. Great to see you all. And thanks, Vera. Appreciate your stories.
Thanks,
Have,
Jen.
have a great night.
Good night, everyone.
Thanks. Bye.